My name is Evita Tolu and I'm an immigration attorney. I often advise clients with criminal convictions on the immigration consequences of their guilty pleas. To determine how a criminal conviction affects you, your attorney first must determine your immigration status. Green card holders may be deported from the United States if they're convicted of an aggravated felony, a drug offense, or a crime of moral turpitude, such as stealing. Aggravated felonies are defined in the Immigration and Nationality Act broadly, and a lot of state misdemeanors are classified as aggravated felonies under immigration law. For example, in some cases, a one-year sentence, regardless if it resulted in probation with no actual confinement, might be an aggravated felony under immigration law. If you committed a crime of moral turpitude, such as stealing, within 5 years of your admission to the United States, you may be deported. Therefore, it is crucial to contact an immigration attorney before you enter into a guilty plea to determine that your plea does not result in deportation at a later date. You can be found inadmissible at a border after a short trip abroad if you have an aggravated felony, crime of moral turpitude, or a drug-related conviction. The United States Customs and Border Protection will detain you at the border to start your removal proceedings. Contact our office before you travel abroad to make sure your return to the United States does not result in detention, deferred inspection, and subsequent removal from the United States. If you're applying for citizenship and you have a criminal conviction, consult your immigration attorney to determine that your guilty plea does not result in denial and, most importantly, in deportation from the United States. Immigrants with aggravated felony convictions are permanently barred from applying for citizenship. If you have a conviction for committing a crime of moral turpitude or a drug-related offense, you are barred from applying for citizenship within 5 years after your guilty plea. You're not eligible to apply if you committed several crimes and have an aggravated sentence of 5 years, regardless whether it was just probation or spent in jail more than 180 days. Such crime as driving while intoxicated or under influence might result in denial of your application for citizenship. Be very careful when seeking immigration benefits because it might result in denial and removal from the United States. Contact our office to determine if you're eligible for relief from removal or waivers of criminal grounds of inadmissibility. Immigration and Nationality Act provides certain narrow exceptions to the general rule. If you're an immigrant facing criminal charges, you need to seek advice of an experienced immigration attorney to avoid removal from the United States and separation from your family and home. Your criminal attorney must advise you of the immigration consequences of your guilty plea. If he or she does not, they're not doing their job. For a consultation concerning your immigration future, contact our office today.